Okay. Morning, everyone, and thank you for joining us for this webcast on the Supreme Court ruling, where we're going to talk about what is a woman. So we should be on this session for about half an hour. We'll have time for some questions as well. If you do have any questions as we go through the session, please feel free to drop them in the chat, and either myself or Michelle and Dawn from within our team will get back to you. Our registration for our next event is now also live. So if you look on the chat, you should be able to see there's a link. And our next webcast is going to be on performance management. So feel free to check that out. And in the meantime, we are going to get going on this month's session. So I suspect you are on this session because you know that the Supreme Court had a ruling recently where the definition of sex, the word sex under the Equality Act 2010 was, well, I wouldn't say decided upon, it was confirmed. So this has had implications for workplace policies, facilities management and inclusion strategies, and we're going to be unpicking that during the course of this week's session. Now, what I am going to say is a bit of a caveat before we get going. This is a bit of a sensitive topic. The commentary that we are giving is relation to legal interpretation. So if there is any offence given, please note that that is certainly not intended. Our aim with this session is to educate and give knowledge. It's not about political opinions. It's not about whether we're saying that this is right or wrong. Or anything around those sorts of subjects. So hopefully you take what we say in the context that it is intended. So let's have a think about context. Now, you'd be forgiven for thinking when we see some of the press reporting around this that the entire case was around the word sex. Now, it was actually a much more complicated issue than that. So if you're not aware, the case that brought this to the Supreme Court was for a group of women that was called For Women Scotland Limited, and it was actually brought against the Scottish ministers. So it was brought against the Scottish government. It went through the Scottish local court before winding up in the Supreme Court after various stages of the litigation process. And what this case was about was in relation to various targets that were set by the Scottish ministers in relation to public bodies and certain boards and organisations, where they were trying to introduce essentially diversity targets and saying that, you know, in relation to these organisations, there was a requirement that, say, for example, 50% of a board was made up of women as opposed to, you know, as we've often seen. And we still see that men are still predominantly present in senior leadership. Now, when talking about that 50% of women figure, the Scottish ministers said that if someone had transitioned from being male to female and had a gender recognition certificate, or simply identified as a woman, that this would count towards those statistics. So you would have someone who potentially, for all intents and purposes, appeared to be biologically male, was identifying as a woman, and that would mean that these boards would have enough in terms of those figures to report that they had a 50% number of women seated on those boards. For Women Scotland Limited disagreed and said that when using the word woman, this should be referring to biological sex, not gender or gender that somebody identifies as, and that it shouldn't include where someone has a gender recognition certificate, including when they are post-op. So this is how we got to court, and this is how we came to have this decision being made. So why does it matter? Well, the ruling affects how organisations manage their policies, their recruitment processes, inclusion initiatives, and also potentially physical facilities. It does help establish clearer boundaries. So what we have seen is companies getting themselves into all sorts of messes and tying themselves up in knots because they can't work out whether, when they are talking about, for example, wanting to have diversity targets, not necessarily saying that I agree with those, but then getting themselves confused over when they talk about numbers of women versus numbers of men, what they actually mean when they are using those words. So, legal implications of this ruling: organisations now need to review their equality policies to ensure compliance and to make sure that when we are talking about protected characteristics, particularly regarding single-sex services and when we're talking about biological sex, that we are talking about biological women and biological men. This doesn't mean that when we have policies where perhaps we do talk about gender or gender identity, that we need to be as strict in those circumstances. We can still have situations where we are talking about gender and we can be using more fluid language in relation to that term. But when we are talking about sex, we are talking about biological sex. Practical challenges. So HR professionals face the challenge of balancing legal compliance with trying to foster an inclusive workplace. So we want all employees to feel respected and valued, regardless of how they identify and regardless of their protected characteristics. And this is a bit of a culture shift. So it's really, really important that we remember that we are dealing with people, that there are people who are going to be upset by this ruling, and putting in place very robust and perhaps not using sensitive language or just changing rules overnight, either without consultation or without seeing how people feel about things or considering how something might land. We have to remember there are still people at the end of the day who are receiving these messages, and it's important that we think about how they are going to feel. Doesn't mean that we necessarily have to change our plans, but it might mean that we think about the language that we're going to be using and perhaps offering some welfare support as well. So let's dive into the protected characteristics. So as hopefully we're all aware, there are 9 protected characteristics. So these are the things under the Equality Act that if we treat someone badly who has a protected characteristic and we treat them badly because of that protected characteristic, that behaviour is illegal. As opposed to if someone doesn't have a protected characteristic, that behaviour could still be bullying, it could still form part of potentially a claim, but it's on its own, it may not be enough to be able to bring a tribunal claim, or it may not actually be breaking the law. Protected characteristics present risk. If you're not sure what I mean when I say protected characteristic, or if you think that actually within your business there are people who don't know what protected characteristics are and that their behaviour as a result could be a risk, we do offer anti-discrimination e-learning. So if that is something that interests you, pop it in the chat and we can send over a demo booking link for you to have a look at the courses that we offer. So in terms of the protected characteristics that are important for this session, now we've got sex, which we now know refers to biological sex, so someone who was born as a man or born as a woman. So if you refuse to hire someone because of their sex, that could potentially be sex discrimination. If you pay a woman who does the same job as a man less money, not only could that be an equal pay claim, but it could potentially, in the alternative, be a sex discrimination claim. So where we're treating somebody differently because of their biological sex. Now, this doesn't mean that people who are trans or people who identify as a different gender, or perhaps say that they don't have a gender, aren't protected. And what you may have seen at some of the protests or the marches that we have seen in the response to this ruling is people saying that trans people have been erased from society. That isn't actually the case, and it's also not the case that they don't have protection. It's simply under a different part of the Equality Act that has always been there. So this is not a new protection. So if someone undergoes gender reassignment, so that can either be through an operation or through simply identifying as another gender, then they are protected under the Equality Act. They have a protected characteristic. So this could be someone who is undergoing a transition or proposing to undergo it. So for example, if you denied someone a promotion because they are due to transition, or they were subjected to harassment because they are someone who is trans, they have protection under the Equality Act. We also then have separate protection in relation to sexual orientation. So this protects people who are heterosexual, homosexual, bisexual, however people identify in terms of their sexual orientation. This is also protected separate from the issue of gender. So if we discriminated against someone who is gay, or if we excluded same-sex partners from benefits, that would be classed as sexual orientation discrimination. So what we see here is that we do have global protection across this entire topic when it comes to sex, gender, and sexual orientation. These are distinct and they don't override each other. So it's important that we recognize that even if this definition of sex has now been confirmed, that it doesn't mean that people under other groups don't have protection as well. Now, what's also important to remember, and this is where it starts to get a little bit sticky, shall we say, is where it gets a bit more complicated. If you've got a situation where you have someone who has transitioned from male to female, and that person is treated badly because people believe that that person is a biological female, even though they're not, that person would still have a sex discrimination claim, because discrimination doesn't necessarily mean the person actually has to hold that protected characteristic. If the bully or the terrible manager believes that person to be a woman and because of that then treats them badly, they still have protection under sex discrimination. And some of the leading cases around this related to, so one of them related to a man who his colleagues believed that he was gay and he wasn't, and he was able to bring a sexual orientation discrimination claim even though he was heterosexual. So it's really, really important that we are making sure that we are enforcing standards of behaviour across the board, that we treat everybody with dignity and respect, because there's no get out of jail card just because either someone's made a mistake or assumed someone has a protected characteristic when they don't. They're still potentially going to have that legal claim. So again, if this is making your head spin a little bit and you think, you know what, my staff and my risk, and often it is the staff, it's the people who are walking around within our businesses who may not understand the intricacies of where the liability could be for your business. It's really, really important that you do look at that training. So what the Supreme Court actually decided then is that when we are using the term sex under the Equality Act, when we're talking about that protected characteristic, we are referring to biological sex at birth. So male or female, not gender identity. So under this case, it means that a transgender woman is not legally considered to be a woman. So you can have someone who was born a man, transitions, goes through the full medical procedure to present as a woman. They would not legally be classed as a woman for the purposes of the Act when we're talking about sex discrimination. Now, as I've already said, transgender individuals do have continued protection and they are distinct characteristics. But what this then presents questions on, and it's a really difficult one for employers, is where, for example, in that instance where you have got a man who is post-op and has transitioned to become a woman and has undergone the full physical transformation, is if we start to talk about separate facilities, are we going to be in the situation where we are requiring that person who, for all intents and purposes, physically looks like a woman and is post-op, and we are going to require them to use male facilities? Now, these are very, very difficult questions that are going to require legal risk assessments, probably legal advice, and written documentation as to how you come to the decisions that you have. Because whilst there may be arguments where we say we only want biological women to use certain facilities because we perceive that there is a risk to their welfare or physical harm if they are mixing with men in these environments, we still have to remember that we have a duty of care towards the welfare of those people who have transitioned, and we need to make sure that they are safe as well. So there's lots of moving parts here. There's lots to consider. And it's really, really important that if you're in a situation where you need to be making changes to physical facilities or you are separating sexes, that you take legal advice for your specific situation. Because just because one company has done one thing and it's been successful doesn't necessarily mean that it's going to work in your workforce. These are very, very individual situations. So we've got a poll that should have popped up on the screen. So what is your organization's current approach to single-sex spaces? So example, toilets, changing rooms. So firstly, we provide single-sex spaces based on biological sex. We've moved to unisex spaces for all. We're doing case-by-case decisions with documented justification, or we're just unsure how to proceed legally because the whole thing's a bit of a mess and we don't know what to do. So we've got a bit of a split here. So these are anonymous, by the way. We don't see who's clicking on where. So it is a safe environment for you to set out in the poll what it is that you're doing. So we've got 45% saying we've moved to unisex spaces, 50% saying provided single sex spaces based on biological sex, and then case by case decisions. Okay, so implications then for single sex services. So we now have the ability to lawfully exclude people on the basis of sex in certain situations. So, for example, in changing rooms, toilets, certain types of hostels, sports facilities, being able to separate based on biological sex has now become something that's more of a safe legal route to do. Bearing in mind, we also still have to have a regard for the welfare of the people who are now going to be either moving into a different space or potentially moving into a space where they could be at risk. So it's not just as simple as separating the sexes. We do need to think about who actually is going to be using which facilities and whether there is any remaining risk of harm and how we are going to overcome that. We need to be proportionate in what we're doing. So if we decide to exclude based on sex, it's got to be in a proportionate means of achieving a legitimate aim. So say, for example, if you decided that beyond your toilets, you wanted your actual workplace to be split by the sexes, well, what's the legitimate aim we're trying to meet here? It's unlikely necessarily to be safety considerations or privacy needs or dignity concerns, unless the workplace is doing something that does have some sort of sex sensitivity. So it's not just a carte blanche to separate the sexes. We've got to be trying to achieve something that's legitimate. And by separating the sexes, that's got to be a proportionate response. So we're not overreacting. We also have to make sure that we are documenting that decision making. So we are justifying what we're doing and why. So we're referring to clear policies, we're using evidence-based decisions, and we're going to regularly review that. We're not just making decisions and not writing down what we're doing or why or what it is that we are relying upon in case those decisions are challenged. So the EHRC guidance, so following the Supreme Court decision where we've had the confirmation of the meaning of the word sex, we've then had the EHRC response. So they've acknowledged the ruling and they've confirmed that lawful exclusions based on biological sex are permitted. And they have given some guidance, which they're also going to be regularly updated. So we are going to be seeing more comprehensive guidance on this to help organisations. And what we're going to do after this session, so we are going to circulate a bit of a sort of survival pack around this topic. So if that's something that's of interest to you, drop it into the chat to let us know that you want it. So this will include the slides, we'll provide some links to the HRC guidance, we'll do you a draft policy, and also a risk assessment as well. So that if this is something either that you think could become an issue, you've got that sat ready and waiting for you. If you feel that you want to be proactive, even if this isn't something that's applicable to your workplace yet, it means that you've got that preparation done ready before this becomes a live issue for you. So actions that are going to be required: reviewing policies, documenting justifications, and ensuring respectful treatment of everyone in your workplace, and ensuring that people who have got protected characteristics, that we are in the very, very minimum complying with our obligations under the Equality Act. And if we think that there is anyone in our workforce that is going to present a risk because of this, because they don't understand what discrimination is and they are stuck in a bygone era, that we consider training. Because if one of your employees discriminates against another, it's likely you are going to be liable for that behaviour if you haven't trained your staff on what is and what isn't acceptable. So case-based scenarios, let's have a look at what can be lawful. So scenario one, where we have got a bathroom redirection. So a company directs a transgender woman to use a unisex accessible toilet rather than a women's facilities. What do we think about this, sending people off to use disabled or accessible facilities? So it's potentially lawful if it's proportionate and it's an alternative to allow someone to preserve their dignity. So when I've said about sending a man who's transitioned to being a woman and who is post-op and for all intents and purposes appears like a woman, sending them into a male facility is potentially going to impact their welfare. So yes, this could potentially be lawful as we're giving them an additional facility. However, we also have to remember that that is then putting pressure on a facility that is designed for another protected characteristic, which is disabled employees. So if that means that disabled employees have limited access to that facility, or it makes it less available for them, we need to consider that we are being proportionate in what we're doing and think about whether actually it is right to be using that facility, or whether we need to either look at investment in other facilities or looking at how we can legally provide unisex facilities. So where we are looking at unisex facilities, I mean, I'm not a health and safety expert, but I believe it has to, we have to be looking at things like floor to ceiling, doors and walls, so that people have got dignity and privacy when they are using facilities at work. So again, lots to think about here. And when I do training around gender identity issues, we always end up talking about toilets. It just tends to be the common direction of conversation. So again, if this is something that's getting you tied up in knots, then please don't hesitate to let us know. But also please don't just, as a knee-jerk reaction, direct people to accessible toilets. You really need to think through that decision to decide whether that is a right course of action or not. Scenario 2, women's support groups. So a domestic violence support service which excludes transgender women from female-only group sessions. Is this lawful? Likely to be lawful if the service can demonstrate that it's a proportionate means of achieving legitimate aim. So their legitimate aim may well be to create a safe environment for biological women who have experienced male violence, and that it is proportionate to exclude men who have either transitioned to women or who identify as women. So when we are assessing these things, when we're talking about proportionate means, often it does mean that we are putting a small proportion of the population at a disadvantage compared to another. And we have to decide, is it proportionate for them to be put at a disadvantage to preserve our legitimate aim in respect of the majority? And that's the balancing exercise that we are doing. It is lawful to do that. But it's really, really important that we can document how we've made those decisions and what we took into account when doing that balancing exercise. Then sports team selection. So a company sports team excludes transgender women from the women's team, likely to be lawful depending on the sport and if there's a justifiable reason relating to fairness or safety, and that we can also look at providing alternative inclusive sporting options. Now, I'm sure we've all seen some of the really, really disturbing reports around where inclusion of transgender athletes in women's sports has produced not just necessarily unfair outcomes, but actually in some instances some really, really tragic outcomes. So I believe there was a rugby game where a woman or a young girl, it might even have been a teenager, don't quote me on that, ended up with a severe and debilitating back injury that resulted in lifelong injuries because she was playing rugby with someone who was physically male. So our legitimate aim there is to protect the physical safety of the women or the girls of the sport, and our proportionate means of doing that is excluding people from a small minority. And again, it's that balancing exercise and documenting why we have made these decisions. So risk and culture, we've got to strike a balance. So we want an inclusive culture. We want to foster respect and have dignity for everybody. We want to encourage open communication. So if people have got concerns or want to give feedback about your policies or what it is that you're doing, that you can take that feedback, because nipping things in the bud is really, really important for preventing legal proceedings. If someone raises a concern and you can deal with it and you can chat to them and you can explain why decisions have been made, you're less likely to face legal action than if people are just ignored and they feel like they've got nowhere to turn. Then also ensuring legal compliance and making sure policies align with law. So the Supreme Court decision is not a license to discriminate, but it is an opportunity to try and foster an inclusive workplace and making sure that your policies and procedures are up to date. And also it's an opportunity to train people. So not only manager training on how to handle sensitive conversations, but that staff understand how their behavior could potentially be breaking the law. So summary and next steps. So review your policies. So audit your existing equality, diversity and facilities to make sure that you do align with the legal definition. Train your managers, document your justifications if you are separating the sexes, and monitor updates. But what I'd also suggest is that you have a think about, well, how can we be more inclusive? So if we're seeing this as a prompt to make sure that we are legally compliant with the ruling, we can also use this as an opportunity to think, how can we be more inclusive? How can we be more welcoming to staff members? How can we attract diverse people into our business? Because we know diversity helps promote creativity and talent. So what can we do to make sure that we are being inclusive for everybody, but then also make sure that we are protecting people's welfare and that we are complying with the law? So I've got a comment here in the chat. So I'm more concerned about being more inclusive. So great, we're on the same page. Being a problem in training, is it lawful to offer women only training programs and allow trans women, those that identify as a woman? We've always accepted them, but not sure if this ruling changes things. So again, it's back to that. What's the legitimate aim that we're trying to achieve? Why do we want it to be women only training? What's at the end of it? And is excluding people proportionate? So I'm happy to discuss this one with you. If you want on a one-to-one, we can have I can book you in for a quick session. That'd be complimentary to take you through it, because it does actually sound like quite an interesting query. So let me know if you'd like us to reach out, and we can discuss that one in more detail. So making sure that we are doing our legal risk assessment. So outdated policies up your risk level to a measure of sort of 8 out of 10. Untrained managers, again, wax that risk assessment for your business up to a level of 7 out of 10. If you've no documented justifications for what you've done, that increases your risk level to like a 9 out of 10. Inconsistent application puts you at a 6 out of 10, and ignoring other protections puts you at an 8 out of 10. Now, this makes it sound like, running a business is a legal minefield. Well, guess what? It is. It's not an easy environment to be running a business these days, particularly with the changes that we are going to be seeing with the Employment Rights Bill and as we get into 2026. It's really, really important that we're not tripping up over the basics, and also that we don't have staff who are becoming a liability for our business. And the only way we can address that is through training and making sure that our policies are up to date. So have a think about a timeline. Think of this as a project. So review your policies, maybe try and do that within the next month. Think about training your managers or training your staff. Maybe look to implement that within the next 60 days. If you don't even know where to start, we have got anti-discrimination training available on an e-learning platform. We can have you up and running in days, and it's super, super cheap in terms of charging per head, and you get a CPD certificate for each person who completes it at the end, which means that if one of your staff does something, you can say, look, Judge, we trained them on this. Here's their certificate. They should have known better. They should be being sued personally on this. My business should not be liable. And we can try and break that vicarious liability link, which is so, so important when it comes to these discrimination claims, because they can be huge. Have a think about your facilities, maybe do an audit and do some risk assessments within the next 3 months, and try and aim for full compliance within the next 120 days. And the pack that we will be sending you after this session should help you to implement that as well. So resources and support, EHRC guidance, make sure you check that out. We will be sending the links across. Join our next webcast. So we operate a little bit like a HR network in that we're constantly putting out training, we're constantly putting out podcast content, and also we host a webcast once a month. So sign up to our content and really try and absorb what it is that we're putting out, because that's really, really going to help you in terms of resources and support. If you feel like you need more help, because that content is free, you don't need to worry about paying for any of that. But if you think, what, I need some one-to-one time with Alyssa or Michelle within our team, or actually you want a bit of support day-to-day managing things with Sophie, then please don't hesitate to reach out. We've got some really, really affordable consultation retainer options for small businesses. Also check out our training materials. We are adding to our training suite regularly now going forward. This is something that we're really, really looking to expand. So if you wanted some micro training on this subject, that's going to be available soon. We've got the anti-discrimination training, and there is going to be a lot more of this coming. So has your policy updated its equality policies following this ruling? We've got 25% of you saying yes, we've fully reviewed. None who are saying that you're in the process of, 3/4 not yet, but we plan to. So that's good. So you can use our template to help you with that. And no, so none of you have said that you're not sure on what to change. So 89% of organisations do need to review their equality policies. 60% of line managers feel unprepared to handle discussions about the ruling, and 75% is the level that you could reduce your risk by if you have proper documentation in place. So yes, these things can be complicated. Yes, it's lots to think about. It might make us wonder why on earth we're in business, but ultimately we can help you with this. So thank you so much for your attention through this session. We have covered quite a lot of technical ground. So the resources will be available afterwards. And like I say, we will be circulating that survival pack. We've got our final poll up on the screen now. So how confident are you that your managers could handle discussions around sex and gender in the workplace? So those results coming in now. So very confident they've been trained. We've got one of you. 3 somewhat confident. They've got some informal knowledge. Not confident they need guidance. We've got 3 in there as well. So look, if that is something that you feel like you need a bit of support with, please don't hesitate to let us know. So how can we help? As I've said, we've got software, we've got consultancy, and we've got anti-discrimination learning. We've got everything. Why would you ever need to go anywhere else? And also, if actually you think, you know what, no, we don't want to buy anything off you, but we do love listening to your content, please don't hesitate to check out our podcast, the HRER podcast, where we take real world HR emergencies, we take them to pieces, and you might be able to pick up some hints and tips and advice from there as well. It's now a top 20 UK HR podcast. We're very, very proud of it. So please don't hesitate to check that out as well. So that concludes this session. If there is anything that you want to reach out to me or the team about afterwards, please don't hesitate to do so. We're always happy to talk to people who've been on our sessions and see if we can help you. And please don't forget to register for the next session on performance management as well. So that wraps up this session. You're all free to get back on with the rest of your day. And if you need anything, you know where we are. So thank you very much.